Hello, everyone, and welcome to today's webinar, Changes in I-9 Employment Verification. Before we get started, I would like to go over a few items so you know how to participate in today's event. You have joined the presentation in listening only mode using your computer speaker system by default. If you would prefer to join over the telephone, just select telephone in the audio pane and dial in information will be displayed. You will also have the opportunity to submit text questions to today's presenter by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we will collect those and address them at the end of the presentation. Today's webinar is being recorded, and you will receive a follow-up email within 24 to 48 hours with a link to view the recording. I would now like to pass the presentation over to Peter.
Thank you. Welcome, everybody. I'm glad you've all joined in this presentation on changes in I-9 employment verification. We have a pretty good attendance here, which is heartening because it shows that folks are taking this issue of I-9 employment verification very seriously. And we'll talk a little bit about some of the issues that arise when it isn't done correctly. But my primary focus is going to be on three changes which have come about more recently in I-9 employment verification and how they impact you and how you do your employment verification. We're all familiar with the I-9 form, or at least should be. It's been called the most complicated little form that there is in the US government, which is to some extent true, given that the answers to questions and the completion of the form isn't as always straightforward as it appears, and that's due in part to the complexities of immigration law and the inability of the government to design a clear form. So let's hop into what I'm going to be speaking about today. As you all know, we've now come out of the pandemic to some extent. People are returning to work. Back at the early days of the pandemic, there were a lot of issues about how I-9 forms would be completed, and DHS ICE implemented a system that provided for remote verification of employment eligibility, what were known as the COVID flexibilities. And those flexibilities, there was an announcement in June, they were going to end. They ended as of July 31st, and concomitant with the end of those flexibilities, there is now an obligation on every employer who verified employees remotely during the pandemic, pursuant to those COVID flexibilities, to now complete in-person physical examination of all such documents provided no later than August 30th of 2023, which is about a week away. Hopefully you're far along in that process or have already completed it. I will talk about that at the end of the presentation briefly, but what I wanted to focus on today more specifically was the second bullet and the last two bullets, which deal with the new I-9 form that was issued on July 26, 2023. This is a revamped form. It has a few notable changes. It's largely stylistically revised, but there are some significant issues that we'll talk about and point out. This new form was available as of August 1st. Anyone who wanted to could start using it as of August 1st. You can continue to use the most recent form until October 31st. After that date, you're going to have to shift over to this new form dated 8/1/2023. Failure to shift over by that date can subject you to penalties if you are audited by ICE because you've used the wrong I-9 verification form. If you have forms in a stack in your office that you use, throw them away, because I've had clients who they have larger human resources organizations, they have several folks who do the I-9 verification, and people would reach into a drawer and grab an I-9 form, not realizing that it might be an outdated edition, and therefore they have an older edition. I've had cases where people have pulled editions that are 10 or 12 years old. which is obviously not optimal. Okay, but either of the forms, that is the new edition or the old edition, can be used for updating the I-9s as required for the end of COVID flexibility. And now the second major point I'll talk about will be the program, the pilot program that's been implemented to authorize remote verifications for qualified employers. And we'll discuss a little bit about who is a qualified employer later on. So what's new on the Form I-9? Well, Section 1 and 2 have been reduced to a single side of the sheet. That has resulted in some removing of the translator certification, the re-verification certification, which are now supplementary forms. As you'll see, that Section 1 translator preparer certification is now a standalone supplement. Section 3 re-verification and rehire is a standalone supplement. We'll talk about those shortly. They have modified the form to remove the lingo alien authorized to work and inserted non-citizen authorized to work, mainly because of the negative connotations of alien authorized to work, but also to clarify other definitions in the form. And they have also added a checkbox on the form that is to be checked if the employer is a qualified employer who's using the remote verification procedure that has been authorized by the pilot program. The form is also designed to be fillable on tablets, and the formatting has been changed somewhat to allow it to be more readily downloadable. Some clients have had problems downloading and utilizing the form because of formatting incompatibility, but apparently some of those issues have been addressed, so it should be more easily downloadable and fillable on tablets and mobile devices. Another change to the form is on the list of acceptable documents. It now includes a section relating to acceptable receipts and significantly a link to information on automatic employment authorization extensions. You will notice in the acceptable receipts, it specifies only 3 specific receipts for List A documents, and then specific receipts for List B and C documents. Note that this refers only to replacement of a lost, stolen, or damaged document, or Form I-9 issued to lawful permanent resident containing an I-551 stamp, or a Form I-94 with an RE notation for a refugee or stamp. The other receipts are for lost or damaged List B documents, or lost or damaged or stolen List C documents. A receipt that someone has applied for an employment authorization card when they do not already have employment authorization is not an acceptable receipt under this rule. That document may, in certain circumstances, be valid for extension of their current employment authorization while their new filing is pending. However, it is not an acceptable receipt. And in order to determine situations in which there has been an extension granted, you should go to this link I-9 Central. It will tell you in specific circumstances when persons' employment authorizations have been extended. Some examples might be an individual who is in temporary protected status, where by regulation they extend the employment authorization. That information would be entered into the additional information block on the form. Similarly, when somebody files for an H-1B extension, the filing of a timely application before the expiration of the current period of stay will result in an extension for up to 240 days of that employment authorization. And there are other circumstances where an application will extend the current employment authorization while adjudication is pending, but those are not acceptable quote unquote receipts. Those are extensions granted by operation of rule or regulation, and they would be addressed in that I-9 central link that you see at the very bottom. I have copied the link itself at the bottom of the slide. If that link doesn't work for you, you can just simply cut and paste it and go to that page. And I recommend everybody do so. The instructions on the form have been significantly changed. They've been reduced to 8 pages from 15. There are now definitions of key actors, which include employer, employee, and more importantly for our discussion today, an authorized representative. An authorized representative is any person the employer designates to complete and sign an I-9 form on their behalf. Employers are liable for any statutory and regulations violations made in connection with the form or verification process. Okay? So if we're talking about an authorized representative, it should be clear that that authorized representative understands the I-9 process, knows how it is to be done and properly completed, and that there should be some type of documentation to designate that individual as the authorized representative for the company. Simply hiring a notary to do it without clear documentation that shows you are engaging them to do the I-9 verification process on your behalf can result in some complications. In all likelihood, CIS will hold you responsible for that regardless, but clearly designating them as such and putting that responsibility on them. And to the extent, if you have a lot of agents who work on your behalf this way, or one who does a lot of remote verifications, you may wish to have some type of indemnification provisions for mistakes and errors that they've caused. But it's important that there be some type of clear designation of authority here so that it is clear who that authorized representative is. The instructions also draw a clear distinction between non-citizen national and non-citizen authorized to work. A non-citizen national is very, very narrow category. It's an individual born in American Samoa, certain former citizens of the former Trust Territory of Pacific Islands, and children of certain non-citizen nationals born abroad. It's not a catch-all for somebody who is an ambiguous immigration status, as it is sometimes interpreted to be. It is a very narrow definition. A non-citizen authorized to work is anyone who has work authorization, but not a U.S. citizen, non-citizen, national, or lawful permanent resident. And with that clarification, they are looking to reduce errors on the forms, and particularly employers' claims of good faith reliance on it, by trying to make it obvious that the non-citizen national is a very narrow definition. There have been added instructions for the use of the checkbox. If you are using the alternate procedure, you must select this box if you use an alternate procedure. Now, there are references throughout through the employer handbook, the M274. A lot of the references prior thereto were fairly specific. That information has been removed in favor of more generic references to the handbook. If you do not have the handbook downloaded and available to you, I recommend strongly that you access it online. It should be available at the ICE website, and download it, read it through, download it in color, and print it in color if you're so inclined. It has very good illustrations of the documentation that's referenced on the list A, B, and C documents, and has some very helpful guidance that you can follow as to how to properly complete your I-9 form. It's not going to eliminate all questions, but it's going to be your best reference for avoiding mistakes. Okay? Now, here's the actual section 1 of the new form. One change at the top is the anti-discrimination notice is longer, more specific than it has previously been. All employees can choose which acceptable documentation to present for Form I-9. Employers cannot ask employees for documentation to verify information in Section 1 or specify which acceptable documentation employees must present for Section 2 or Supplement B re-verification or rehire. Treating employees differently based on their citizenship, immigration status, or national origin may be illegal. For this situation, it's very important that you have very specific procedures on how step by step as to how I-9 verification is done. I have run into multiple clients who have handed the I-9 form to the employee and told them they need to bring in a passport or permanent residency card when they show up for work. That is not appropriate. That is a violation of the documentation rules for I-9s and can result in civil penalties. You need to be very specific that the documentation should be either what is on list A or one each from list B and C. And it's the employee's choice to bring what they deem is most appropriate. There will be times when discrepancies arise between what they provide and what is checked in those check boxes of 1 through 4, and what might be provided additionally in the 3 boxes that are identified by the arrow at the bottom. At that point, it's probably best to engage counsel to discuss how to address that discrepancy, if at all, because there's a very fine line that you can walk between questioning to ensure accuracy of the documentation versus making a request for specific documentation. So those two issues are interrelated, and I wanted to point that out on the I-9 form. You should note most of this is similar to what existed previously. Absolutely imperative that the employee sign and date it. Use a social security number is optional for employees, and you'll notice that that is included in the instructions that will tell you if you read through the new instructions for the form. So here's the new section 2 of the form. It's a little more organized than has been in the past. Has room for additional documents and title. Please make certain that when you fill out this form, you complete all of the boxes: issuing authority, document number, and expiration date. That goes for A, B, and C. Do not simply write Maryland driver's license and then the license number. You have to fill out that all of the 3 boxes of requested information for each document. You'll note I put a little arrow next to the tick box for the alternative procedure. And that is where you would make your check if you are qualified for and use the alternative procedure. The additional information box can be used for additional information that may relate to verification, but is not necessarily a re-verification, including a rehire. This might be where you'd put the information regarding an extension granted by regulations or an extension of an authorization granted by a timely filing of an H-1B extension application or an L extension application, as the case may be. And this is, I did not put in the translator certification. That has not really changed in format. It is just a page now with 4 separate identical blocks. The supplement B is very similar as well, but this is what the new re-verification and rehire, formerly known as Section 3, is. And that is when somebody has expiring employment authorization and you need to re-verify them. That would be with somebody who has work authorization that expires pursuant to an H-1B visa, or if they have expiring work authorization due to an expiring employment authorization document. An individual with an expiring green card is not somebody who needs to be rehired, re-verified. Okay, so that is the new I-9 form. I want to move to now the remote verification flexibilities that have been introduced by final rule. This pilot program has been put in place because DHS determined that there was not a significant incidence of fraudulent activity through the remote verification procedures during COVID, but nevertheless, they feel that they need to limit the pilot program so that they can gather information and data to assess whether or not this is a reasonable precaution against fraud. And I point this out specifically, as the general rule is the employer's authorized representative has to physically examine the document to ensure that they appear to be genuine and they relate to the person who is providing them. That can sometimes be hard to do because of the sophistication of forgeries, but in most cases, physically examining the documents can offer clues such as the lack of security benefits. There may not be holograms, microprinting, the cardstock may be different. In some cases, the document may look like it was written with crayon, which has been the case a couple of times. You may see where the printing is off kilter, not in a line. You might appear that things were erased on the document. A number of other issues which might raise questions regarding the genuineness of the documentation. And from DHS's standpoint, employers who physically examine the documents can see these security features much more clearly, okay? And so they designed this alternate procedure with these concerns in mind. It's, in a sense, it's almost like belts and suspenders, because the procedure is only available to people who are qualified employers. That is, those who are in good standing in E-Verify. And if you know, E-Verify is a program that you enroll in with the federal government. You sign an MOU, you go through training, and you then utilize that program to verify your employees' work eligibility by accepting their documents, then uploading them to the system, and you'll get a confirmation, tentative confirmation, or a non-confirmation that flows out of the E-Verify to tell you whether that person who has provided those documents has provided legitimate documentation authorizing them to work. So what E-Verify does is it provides you essentially with a good faith defense to an unlawful hiring. It does not give you a free pass from the I-9. You still have to do the I-9. However, it is a process that gives you at least some comfort that you're not going to intentionally hire or unintentionally hire somebody who is not lawfully authorized to work. So what does it mean to be in good standing? It means that you've enrolled in E-Verify for all the hiring sites using the alternative procedure. It means that you're in compliance with all requirements of the program, including the verification eligibility of new hires. There are a number of companies I've run into where they've enrolled in E-Verify and then they've let it lapse. They haven't used it in many years, and they would not necessarily qualify as in good standing. And you have to also continue to use the E-Verify and remain in good standing while you're using the alternate procedure. You can't just institute it for one or two folks and then discontinue it. You have to do it in all circumstances for all employees. Now, that doesn't mean that all employees have to be verified through this process, but if you have employees who are reporting to a particular site that is the hiring site for the alternative procedure, every employee at that hiring site must be covered by, new hires must be covered by E-Verify, and it must have been your practice going before the implementation of this procedure in order to be qualified. There's no real process that I can see that gives more clear guidance than that as to who is in good standing, and it's going to be case by case based on audits. An employer may opt to use the procedure for remote hires only and apply the physical document inspection procedures for on-site and hybrid workers, provided it's done non-discriminatorily. Employers must complete the E-Verify tutorial, which applies to all persons who verify documentation and includes fraud awareness and anti-discrimination framework. Employers using the alternative procedure must retain clear and legible copy of all documents presented by the employee seeking to establish identity and employment eligibility for the Form I-9. My concern here is, and it goes back to the prior slide, I discussed the security features, is that there may be targeted audits for employers who are using the alternate procedure. That's not necessarily a bad thing as long as you're in compliance. But I think it just puts you on notice. They're creating this pilot program. They're going to test it out. And when they test it out, that means they're going to come and identify E-Verify employers using the program. There's no requirement that you report that you're using the program, but that just means that your audits will be more randomized. That's just a hunch. To date, ICE is stretched very thin in its investigatory authority, and they have take a long time to complete audits. They don't have enough agents to do so, and they've been mainly relying on target industries, suspect industries where there's a lot of fraud, and on complaint-driven investigations. But they could change their goals to some extent to see what extent they're getting success with this new pilot program. Now, bear in mind that E-Verify, and those of you who use it now, that all List B identity documents presented by the employee must contain a photo and use data sources available through the Department of Homeland Security for electronic verification. That's one distinction between I-9 verification and when you enroll in E-Verify and how it modifies the documents that may be used. So what's the process for this remote verification procedure? Within 3 business days of an employee's first day of employment, a qualified employer or authorized representative acting on their behalf must first get a copy of the documentation the employee is going to utilize for verification, okay? And examine copies front and back of the document if it's two-sided to ensure the documentation presented reasonably appears to be genuine. Conduct a live video interaction with the individual presenting the documents to ensure that the documentation reasonably appears to be genuine and related to the individual. There's no script that has been provided. There's no information that they have as to what questions you may ask regarding the documentation. My recommendation is if you look at it, you keep it as you have been, that you look at the document, you ask them, you identify the document, confirm that's the document they provided, confirm the information on the document that they provided to you, and then do an inspection of what has been provided to ensure that there's nothing unusual about it, that they're going to have a photo ID, make sure that they look like the person in the photo, and the employee has to, that documentation they give you up front has to be the same documentation provided during the live video interaction. On the I-9 form, you would tick the box that the alternative procedure was used to examine the documentation, and then you're going to retain, consistent with the regulations, clear and legible copy of the documentation, front and back if two-sided, And in the event of Form I-9 audit or investigation by relevant federal government officials, you're going to provide clear and legible copies of those documents to the auditor. Okay, so are there additional document retention requirements associated with the alternative procedure? Yes. As I noted above, qualified employers must retain clear and legible copies presented by the employee. This only applies to employees for whom the employer used the alternative procedure, not all employees of the employer. So if you do not regularly collect documents, you simply complete the I-9 form, inspect and return the documents. You would not need to keep those documents as long as it's not following the alternative retention requirements or the verification procedures. But that rule, how you handle the documents, must be done in a non-discriminatory fashion. Qualified employers may begin using this procedure starting on August 1st. And if you're not enrolled in E-Verify now, you can't use it to re-verify as a procedure for verification with respect to the individuals who you verified remotely during the pandemic. Those not enrolled in Verify can do so after becoming a participant in good standing by enrolling and receiving the required training. So you can't, it's not retroactive because presumably if you enroll now, you weren't enrolled when the documents were originally inspected. If an employee does not want the employer to use the alternative procedure, you have to respect the employee's wishes. And in that case, you would do the normal in-person document review. It says, and can qualified employers that were enrolled in E-Verify during COVID-19 use this alternative procedure? Yes, they may, provided that they were enrolled in E-Verify at the time they performed a remote examination. They created an E-Verify case for that employee at the time, and they performed the remote inspection between March 20 and July 31. They may use the remote procedure to satisfy the required physical examination of the employee's documents for that Form I-9. Such employers should not create a new case in E-Verify. All employers that use the procedure instead of physical examination must follow the steps of the alternate procedure and add alternate procedure with the date of examination on the form in section 2 and additional information on the form in section 3 as appropriate. The alternative procedure does not expire, but DHS may amend or cancel it based on the Secretary's determination that doing so is necessary to maintain a level of security. This is what is in the regulations, and to my reading, a suggestion that they may step up audits to test this process. And DHS is expected to monitor and evaluate the data and information from ICE audits conducted to assess measurable impacts on system integrity. And this is all from the regulations, and again, why I believe we may start seeing some stepped up enforcement along these lines to test the procedure. And the last point, which I will talk about only briefly, the end of remote document verification. Non-qualified employers who do not qualify for the new remote verification procedure program are required to complete in-person document verification for all documentation verified remotely during the COVID flexibility period, meaning in-person verification for those employees completed by August 30th, 2023. You should have already, if you have not done so, identified all employees whose documentation was verified under the COVID-19 program flexibilities and implemented a process to ensure that everything is done by the deadline. If an employee is no longer employed, you can make a notation on the additional information box on the form for that individual employee. The in-person verification can either be completed with a new form or a notation on additional information box recording the date in place of in-person verification. If the document was unexpired when initially presented but is now expired, the employer should not request a new document and may proceed with physical inspection of the documentation initially presented. Of course, that if it was work authorization document that was expired, that of course raises a question about re-verification. But they're talking generically here about, say, if they presented a driver's license at the time, which is since expired, or a passport. Best practice with new documents different from those initially presented is to use a new form and staple it to the original Form I-9. And if you have an employee who is working remotely who refuses in-person verification, including those who refuse to travel if necessary, say where you are not able to get a representative, an authorized representative to go to this person's residence or office location, wherever it may be, and complete the verification, those persons may not be employed past the deadline. That is the extent of what I wanted to discuss. I look like I have one question so far about the form. Is there a plan to make issuing authority back to the drop-down menu like former I-9? I don't know. I haven't accessed the electronic version of the form to be able to determine how that. I haven't gone on and actually downloaded and fiddled with it to see. Obviously, if there are comments and questions, you can submit them to ICE through the comments and questions link that they provide in the regulations. If you can't find it, I can assist you in locating it. It's certainly valid because it helps you in terms of completing the form. And if it's a drop down that is locked and you're unable to put in a document that is not listed because it's not listed there, then the question is it an accurate document that is acceptable document? And if it is an acceptable document, it may be that you have to include the information in the additional information block. So that is what I know about that at the moment. It does not appear that there are any additional questions right now. That's all I have for now on the Form I-9 and the COVID flexibilities. And I thank you all for listening and wish you all the fun you can have in filling out this new form. Thank you.
Thank you, Peter, and thank you everyone for attending today's webinar, Changes in I-9 Employment Verification. As previously mentioned, you will also receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar. On behalf of Whiteford and our presenter, thank you for joining us and stay well.